Recently, just moved this program was actually beautiful. But after a lot of consideration, that I know the US I have this way I started what I do. So I think it's a project that we have in this case. That we have and I just want to that's why discuss and I want to request if you have time, then visit our website about us and why we are doing what we are doing. Actually, I was thinking of human rights. You know what? What are abilities? So, my partner, he's very I've been on this project. And I think my first time was online. Now, we are other partners. The first partner is First Law Foundation. First Law Foundation is based in the United States. We have a platform. What First Law Foundation does is connect problems across the world. Now, what they do is connect, so you have an entity, you come up with an idea, then cross door business platform. So draw very express interest.
Morning. You're looking good. From level. When high.
In terms of booking conditions and what's happening within that sector, how people are working like electronics.
Just hold my phone like this.
How people go to work, security guards go to work and they get terminated. Nothing happens. So that was my concern. I wanted to speak to that problem and see how
every other person on online should mute. You are online. You should mute so that we are not only you to.
Is every other person that is online, please mute your mic, please, so that you can hear me clearly and so that I can also hear you when you want to speak. So that was actually my concern. And so I started looking for help for others. How do I make this a concern? Okay. And so I started going online, searching, looking for lifelines, speaking to that problem. Anyway, it could be here and in South Africa, it could be in Mexico. Everybody's looking to that same issue. Probably I can learn from that person to see how I can, borrow what's working there and all that. So I started with online. So while I was online, sorry, please, the one thing. So in the course of my search was how I got to be first of all. So we started communicating. So I got to know that they can actually help. So I placed my idea on the notice board for them because I actually have to meet with you, have do discussions with you until you are able to prove the solid point that your idea was so honestly, and then hello. So on that note, I cross-law, we started talking. My partner, but let me just be smart a little bit. Abdul, tell me the other name. So Abdul had a concern. His concern was for the construction sector. How they are. So Abdul too was online looking for like minds, people that are working to defend those people that are working within that sector. So it also stumbled on Trust Law Foundation. And Trust Law Foundation is idea. After looking at foundation, after looking at idea, similar concern. So they call for a meeting. They send call for a meeting. Can two of you work together? Can two of you work together? I didn't know you. I've never heard of organizations. I've never heard of organizations. Never do. He's Lagos Avenue. How can we hold people accountable? Without framework. So he did a research work. That work today 8 months. So it was, we had to read documents. I'm not a lawyer. learn new things. So after 8 months of research, we came up with a report. And we handed over the report. So we can approve. So we can approve, reason together. I said, no, this is too beautiful. There's a report. Let's even just end it off. Why don't we make it a booklet so that it can circulate, it can go around, people can read. First of all, then studying online, downloadable format. So we said no. Because that is online. But there's a way to do it that push that it can be in libraries across the world. At least when people are doing research of something close to what we are speaking on, people can be there. So we have put on this in a booklet which we will share with you. So we will share with you today. So on that note, I want to invite Abdul.
No, they are not.
Thank you very much. I think he has said, already mentioned, he has already mentioned almost everything that like to also it's like what he said, every Nigerian workers are facing this kind of challenges. Challenge that the employer can just employ you when he feels that he wants to employ you, not because of your qualification or what you qualify. You can have the right professional certification, but he can decide to give you something lesser. And one big thing is he knows the condition is very, very tight. Probabilities are not too good that you take that condition. And again, even if you want to do something about it, there's nobody for you to speak. That is one. The two, most of the workers too, they do not know their right as a worker. What are you expecting from your employer? So our thinking is first you need to know what you are expecting to get from your employer based on the work that he has given to you to do. Because
Most times also, we also feel that probably maybe employers too are not much aware. But this research work have become a book, talk about the employer's right, talk about the employee's right, talk about if these rights are violated, instead you can take. But one of the here is the Google's part of the job. Because in most cases, the company do otherwise. The employee can still know his rights, but he doesn't have any muscle or what it takes to fight the employer. But if we have criminal lawyers like you and I believe by the company or employer just hearing from a third party, maybe a non-firm written to a company that so person the right has been infringed in this way, and we want you to resolve it. I think they will take it serious. When just that employee, including it that is speaking. So what this job or this document does is we enable the employee to understand the rights. The employer also, they create an avenue where they can reach out to a criminal lawyer if any of their rights are being infringed upon. I think that is why we are here, and we are very happy that we have this group, and we are just happy from here because something that we do almost all in 6 zones. Thank you very much for coming.
Okay, please, we'll just go around so that we can know ourselves in the room. Please, I don't know, just give your mic, please. Give us your name, your organization.
Good morning, everyone. My name is Sajana from Kaduna State Ministry of
All the two. All.
And before we go on, like, take messages from those that need to prosecute. I also want to continue. I also want to introduce one of the partners. One of the partners.
Let me send you the link. Go and register, you can do it.
Something. So, I don't know. I will leave the
We are done.
yes, please. So they will, or like 5 minutes on the partners, and then from there, from there and do. And moreover, it's an interactive session. We want you to ask them questions. Because me, I don't know anything. You ask them questions. They're bigger professionals like themselves. What they do is that we research reports to handle will be available to you. And also what they will do, whatever they will present, the slides, we will share. That's why we have the document. Share the document. And they will tell you what they know what they have in mind, why they are going forward. So keep your mind open and let your mouth.
Have you seen it?
Thank you.
It's do sharp sharp.
You can go.
Yes. Thank you very much, Dennis. So at this junction, we want to start with you guys over there. At this junction, we want to start item 3, I mean. Item 3 is message of partners and collaboration. So,
Hello. Yeah, Christina, can you go to give us a message from me? The floor is yours now.
Hey, thank you so much. Can you hear me?
Yes, please. Yes, please.
Okay, wonderful. So my colleague and I will do a message from Lowenstein Sandler. I'm hearing some feedback. I'm not sure if it might be helpful if we muted, that would be great. Thank you. So good morning, everybody. It's so nice to be here with you today, even if just virtually. I regret that I couldn't hear everything that Dennis and Abdul said, because I'm sure it was wonderful, but just seeing your faces and knowing that we are together to promote workers' rights and doing it through the mechanism of pro bono just brings me so much joy, and I thank you for inviting us. My name is Christina Holter, and I am the Corporate Public Interest Counsel at the law firm Lowenstein Sandler. We are a mid-sized law firm in the United States. We have about 400 attorneys, and all of our attorneys are encouraged to do pro bono work. We have a Center for the Public Interest that houses our pro bono efforts. And we are very fortunate, and I recognize very privileged to have 4 attorneys at our law firm. Even though it's a commercial law firm, 4 of us are exclusively dedicated to pro bono work. We were absolutely thrilled when this opportunity to help children and young people living for peace and International Society for Peace and Safety on this workers' rights initiative. It came to our attention through another partner organization, Trust Law, that will introduce themselves in a little bit. But it caught our eye because we so well written and kind of well conceived. Our clients, the 2 CSOs, spelled out exactly what they needed us to do, what research points. And we were very intrigued that the impetus for this was to educate not only workers, but also employers about workers' rights and employers' obligations. And that underlying the whole project was a spirit of cooperation between those 2 constituencies. And I could have never imagined at the beginning of the research project, so I should say we were brought in to do research on workers' rights and produce a guidebook, which we did, and a Know Your Rights brochure, which we prepared. Doing pro bono training wasn't part of the initial plan, but Dennis and Abdul lifted that up as a strategy that could actually bring the research to life. And I am thrilled, as someone who believes very, very deeply in the mobilization power of human rights and the law to effect change. I'm just so thrilled that we are doing this together. And I'm also a proponent of pro bono, not just because that's what my job description involves, but also I believe that it's a way that we as lawyers can contribute to our communities, can move the needle on advancing access to justice. So I'm just really pleased to be with you. And I would like to turn it over to Tolu, my colleague, because he has a very special connection to this project that you would be interested in knowing about by virtue of his background.
Thank you so much, Christina. Good morning, everyone. I don't know if you guys can see us. It's actually 5:49 a.m. here, so it's pretty early. My name is Tolu. I'm a second-year associate at Law School Sandler, and I'm a corporate attorney, but I work on pro bono cases, courtesy of Christina, and I appreciate that every time. This project is particularly dear to my heart, being that I'm also Nigerian. I was born in Lagos, came to the United States for school, and I work here in New York now. So for me, when the project came, I took it with a lot of excitement because before I moved to the state, I also worked in Nigeria as well, and I faced a couple of issues back in Nigeria, especially with employers, and which of the things we're going to be talking about today. And I think it's very interesting that it's like a full circle for me, being that I haven't worked in Nigeria before without even issued any employment letter, which by virtue of the law, I needed to have been provided with that at that point. So for me, I'm very excited to be here and to talk more in details when the time comes and when the time permits. So thank you so much for the invitation, and thanks so much for to Abdul and Dennis for the invitation as well.
The last in line is trust law.
Thank you so much, Abdul Ghani, and Christina and Tolu taking the lead on introducing a background on this research. I hope you can hear me well. Thank you for the thumbs up. I had a presentation, but I've seen sharing screen has been disabled. So I'll just go through a brief overview of the Thomson Reuters Foundation and our pro bono service, that is Trust Law, that facilitated this connection between the two CSOs, ISOPS, CYPLP, and Lowenstein Sandler. I hope. Sorry, I just had another voice, but yes, I'll just take about 10 minutes or less to give you a brief overview of trust law. I'm aware that people in the room is filled with pro bono lawyers who might be interested, and I hope you're interested in taking up more pro bono, whether it's through your institution, through clearing houses, but of course, considering trust law as well. So you may be wondering who we are, the Thomson Reuters Foundation. We are the corporate foundation of Thomson Reuters, the news organization. We are independently registered as a charity in the UK as well as the US. At the foundation, we have three primary areas of focus: promoting human rights, advancing media freedom, and fostering inclusive economies. That's all corporate speak for just saying that we want a better, more inclusive society. And at the foundation, we run a number of programs and services that would largely fall within those three focus areas. We have a new service. We have journalists on the team who will write stories that are underreported. We also have convenings. So we run workshops, trainings, etc. And as well as our annual flagship conference that usually happens in October every year. We also have, pardon me, we also have a media development program that trains journalists on different topics. So reporting on climate change, reporting on AI regulation, etc. So any emerging issue that journalists might want to get skilled on. And lastly, but of course, what we'll be speaking more about today is trust law, which is our pro bono legal service. So within the service we have, it's a membership service comprising NGOs and social enterprises on the one hand. And then on the other hand, we have our rockstars, the lawyers, law firms, corporate counsel, so in-house counsel, who provide pro bono services to our CSO and social enterprise network. And what we do at Trust Law is facilitate connections between the beneficiaries and the lawyers. So one good example are the two members, or three members, I should say, who are whose I would say we are celebrating today. ISOPS, CYPLP are CSOs, and we have Lowenstein Sandler as lawyers. So we facilitated that connection that brought this research to life. So you may also be curious, as lawyers in the room, there could also be some CSOs in the room, how we do this. So we have two kinds of support we facilitate: advisory support, that is the day-to-day health of either the CSO or the social enterprise, where we facilitate connection to get legal support on intellectual property, employment law, corporate law, IP, you name it, any legal issue that CSO might face on a day-to-day basis. And then we have research support. A good example, again, is what we facilitated between the two CSOs who are hosting this event and Lowenstein Sandler. Just to give, I guess, a last overview, the service is free to join, free to use. There's no expiry date, so it's for life. If there are any organizations, law firms, individual lawyers who are interested in joining the service, I've shared a presentation that has my details. Please feel free to reach out, ask as many questions as you may have about the service, but otherwise really, really excited to dive deep into the agenda of the day. Thank you so much for this opportunity, Abdul Ghani, Dennis, as well as Lowenstein, for carrying us through this project for a year. Thank you.
Please, Fred Young, the floor is yours now.
Hello, can you hear me?
Yes, we can.
Can you hear me, please?
We can, Emmanuel. Yeah.
Yes. Good morning, everybody. Thank you for this wonderful opportunity to participate in a laudable workshop like this. My name is Emmanuel Ekpenyong. I'm the managing partner of Fred Young and Evans. It's a full-service commercial law firm in Abuja, Federal Capital Territory. We engage in a number of commercial activities, and we've participated in public interest litigation, like the recent matter on Kama, in which the Companies and Allied Matters Act that was enacted in 2020, some sections actually infringe on the rights of persons in Nigeria of freedom of their thought, conscience, and religion, as well as freedom of association and peaceful assembly, in which we challenged that in court, and the court actually expunged those sections that infringe on the right. So and also the right to life, for the court to determine the extent of the right to life. So we are actually very, very enthusiastic on enforcement of rights in Nigeria. That is why we are very proud to partner with this laudable initiative. Then we also, in a very special way, want to thank the organizers, the two CSOs, the sponsors of this show, this program, for the insights they have to organize this program. It will go a long way to achieve the aim of creating awareness for the Nigerian workers. So it's a laudable one. Then the role of the Nigerian workers and workforce, they strive. That is why if there is any industrial action as well as any strike action, most organizations or even the economy itself will be at a standstill. So the workforce is an important decimal in the life of any organization. So, and they should be taken very seriously. But this is not the case in Nigeria. Like in other climes in which there are more, welfare, there is more activism on the rights of workers as well as people who participate in the growth of an organization. In Nigeria, there are still many work that we need to do to bring the Nigerian worker to be in line with the international standard. Now, there are many legal issues that pertain to the Nigerian worker, in which workshops like this will go a long way to create the necessary awareness. Some of the legal issues that we have identified include lack of employment. What happened to skilled workers, unskilled workers, semi-skilled workers when they do not have employment? How do the law take care of them in such an instance? We also need to talk about the legality of the terms of employment. For those who are employed, how is the terms of the employment? Is the employment such that is able to take care of the worker, or do they just feed from hand to mouth? These are some of the legal issues in which it need to be addressed in Nigeria. What are the working conditions of the Nigerian worker? Is the working condition of the Nigerian worker, does it meet international standard? And what is the society doing to improve the fortune of the Nigerian worker? And also, when there are hazards and deaths, injuries at the workplace, how is the worker taken care of? How is the worker taken care of? Now, what about instances where the employment of the worker is terminated due to redundancy or lack of work, or the company or organization is packing up? Do they consider the welfare of the worker in such an instance? So again, how do the Nigerian worker enforce his labor and employment rights? These are some of the issues that are agitating my mind when I heard about this workshop, that I believe that a workshop like this should be able to address, and in the long run should be able to cure it as time goes on. So what I look forward to, the benefit of this workshop, is to create awareness for the Nigerian worker, for them to know what are their rights, what are their obligations to their employer, and what obligations do they have? Because if there is no awareness, there is no how they can actually enforce some of these rights. Then I also want to talk about the role of the civil society, as well as labor and employment pro bono lawyers and the media. The civil society groups, especially those in labor, should be more proactive in reaching out to Nigerian workers that are indigent, that cannot provide, the services of a legal practitioner. Some of these things, they have to be serious activism, so that even the organizations as well as the companies will also know that Nigeria, that they have an obligation in to the Nigerian worker. So the CSOs, thank God that the CSOs is being invited, and also pro bono lawyers, there should be a great awareness, because we already know this law, and law is an item we can use to change the society. And it's not only for those who can afford our services, most especially those who do not, who have good cases and whose rights are being infringed, but do not have the wherewithal to afford our services. And of course, the media creates awareness of, some of these injustices in the workforce and in the labor units in Nigeria. So the essence of this workshop should not just be a workshop. I will propose that we should take steps, active steps, to ensure that the benefits of this workshop actually goes to the root, so that the Nigerian workers spread across the world will tend to see the benefit of workshops like this to improve the status of the Nigerian worker in Nigeria. Thank you for this wonderful opportunity you have given to me. Thank you for everything.
At the end, I think we give allow you, she is a lawyer. She's a Nigerian, but she lives in
Good morning, everybody. Would it be great for me to come up during the item 6, please? But it's a pleasure to be here, to see this finally coming on, and to see the faces in the room. My name is Ada Obi Ebuka. I direct the Africa program of the Venn Center, but I'm happy to come back later on item 6. Thank you.
Okay, that's fine. That's fine with us. We will sit with that. Okay.
Yes, sir. This is the note there. We are now in item 4, right? Yes, you can move to the training now. Yes.
Okay, great. Thank you so much, Abdul. And I'm going to share my screen. Okay. Are you able to see the slides? Yes, thumbs up. We're able to see the slides?
Yes, Christina. Yes.
Okay, perfect. And I hear a little bit of feedback, so I'm not sure if maybe muting might help. Thank you. Thank you again. So today, Tolu and I are going to be delivering a presentation, Workers' Rights in Nigeria, a legal overview. Everything that we're discussing is covered in more detail in this beautiful guide that Trust Law helped put together. And so I'm not sure if those have been printed and distributed yet, but you'll be able to read about all of the topics in more depth. There is also a one-page brochure that is a Know Your Rights guide that we intended to be a plain language guide that could be shared with workers and employers to increase knowledge on the topics. So with that introduction, we will get started. So we wouldn't be good lawyers if we didn't start out with our standard disclaimer that this presentation is offered for information purposes only and it's not legal advice. Individuals should seek advice from qualified legal counsel in relation to their specific circumstances. As Tolu said before, and I'll say again, neither of us are employment lawyers. That's not our background. But I think this is a prime example of how, as pro bono attorneys, we can step out of our comfort zone and use the legal skills that we gained in law school and through practice to learn enough about new areas of the law that we can help people who aren't lawyers claim their rights. And so it's with that spirit of kind of shared learning, but not as an expert, that we are going to be delving into these topics. And I'm sure there are many in the audience who are more expert on many of the issues, and I hope that you'll chime in at any time, either during the presentation or during the Q&A, to share your more specialized local knowledge. Here's a brief roadmap of what we'll be going over in the next 55 minutes or so. First, we're going to talk about the legal framework governing workers' rights in Nigeria, and we'll cover the national laws from the Constitution to the statutes. We won't go into state law. That's beyond the scope of the research that we did, but of course, when you're evaluating a specific rights violation, you'd want to look at whether there's state or local laws that apply. Then we're going to move into rights applicable to different categories of workers. One thing that really struck us as we were looking at this topic with fresh eyes, as again, we're not employment lawyers, is that some of the laws in Nigeria apply to all workers, such as, of course, the protections in the Constitution and some others. And some only apply to formal employees, some only formalized employees. Some apply to large employers, but not smaller employers. So it's helpful to just drill down as to what national rights apply to which categories of workers, because that also helps us think about what areas might be good targets for advocacy to perhaps expand the laws. Then we'll turn briefly to the legal responsibilities of employers and employer penalties for labor-related misconduct. We'll then move to complaint and other enforcement mechanisms, both national, but also regional and international. We'll talk briefly about compensation for rights violations, and then we'll spend a good amount of time on recommendations for government, for civil society, for employers, and for employees. And I just want to say that we at Lowenstein are very happy to be a resource for anyone who might be attending today or at a later iteration of this program offered in another state, as you're thinking through how to develop a pro bono program that would help workers. And I know that Trust Law and the Vance Center are also there to offer that support. And also, I know that Emmanuel from Fred, Young and Evans is perhaps the most, local and fruitful resource for this. So there's so many ways that we can work together to move this forward. Okay, and with that, I'm going to turn it over to Tolu to talk about national laws governing workers' rights in Nigeria.
Sorry about that. Good morning once again. Thank you so much, Christina, for that wonderful introduction. As Christina rightly said, we're corporate attorneys, although I do corporate law, Christina do all sort of other pro bono cases, but I primarily do corporate law. So I'm not an expert in labor law or employment law. I just want to make sure in employment. on account of sex, any of the ground. And as you may know, there's a lot of issues around Section 17 of the Constitution, especially when it comes to non-justiciability of that section. So that is not topic for today, but I just wanted to put it out there that Section 17 might not be enforceable in court and is not a fundamental human right. Another issue that I like to put out there also is Section 40 of the Constitution, which guarantees the right to freedom of association to all citizens in Nigeria. As a result of that, you know, with the reading of the combination of that together, can you guys hear me? Okay. I just got something in the chat that I need to be audible. Thought I was audible enough. So Section 17 and the Constitution provides, you know, prohibit any discrimination against workers based on arbitrary employment classification. And that takes us to Labor Act. So Labor Act is the principal law governing labor relations for workers in Nigeria. And Section 91 of that act defines workers to include any person who has entered into or worked under a contract with an employer. And whether that contract is for manual labor or clerical work, or whether it's expressed in writing or implied or oral, that if you're that person, then you come under the definition of a worker under the Labor Act. Another worthy of note about Section 91 is that it excludes some certain workers, some categories of people, such as people with public office holders. So those people are not under that. So the implication of that is that any right or entitlement under that law, those people will be excluded from that. If we take a little bit step forward, we talk about Trade Union Act. Trade Union Act is also part of Laws of Federation of Nigeria as of 2004. And what the law does is that it provides for the right of workers to form a trade union or join an existing trade union available. So the act applies to any combination of workers, employers, whether they're temporary or permanent. And the purpose of the act is basically to regulate the terms and conditions of employment. And the statute also applies to all workers, whether you're a casual worker or you're a permanent worker. So there's really no bias when it comes to employment classification with that. Moving forward, we talk about National Minimum Wage Act, which was as 2019. And this particular act requires that if an employer have over 25 employees or more, you're required to pay minimum wage of no less than 30,000 naira, which to me it's really small. And I hope this law eventually change one day. But as we have it, that's what we have right now. However, the law exclude from the national minimum wage for workers employed on a part-time basis. So if you're employed on a part-time basis, if your employer does not pay you 30,000 naira, there's really no guarantee under the National Minimum Wage Act. Also, there's also exclusion for workers in the agricultural sector. So if you work in the agricultural sector is also excluded as well. Also, a person also employed in vessel or aircraft, you're also not covered under the National Minimum Wage Act. So what that means, in putting that into perspective, is that the law does not cover casual employees whose employment is a part-time or temporary in nature. So the next one, we're going to move to Employee Compensation Act of 2010. This particular law applies to both public and private sector. And what it does pretty much is it establishes a scheme for employers who suffer any sort of work-related injuries or if it results into deaths. And it requires that employers to deduct 1% from the monthly salary of their employees in order to finance this particular a fund called Employee Compensation Fund, which makes payment to employees and their family members in the event of death or pay for their health or medical bills in case of injury. So pretty much the law includes formulas for determining the amount of remuneration paid to the employee based on the scheme available. So that you can find more about that in the guide. I will move quickly to the Pension Reform Act. And so the Pension Reform Act pretty much talks so much about the establishment. And I just saw that my note is a little bit different from what is in the slide. So pardon me for that. So the Pension Reform Act governs the establishment, the administration and payment of retirement benefit to employees in Nigeria. And it's very mandatory for private sector employers that if you have employees more than 15, then you're required to set up this retirement benefit for your employees. And one thing of note is the statute actually defines what employer means. Employer here means a business that employs 3 or more employees. And it defines employee as any person employed in a private company organization. So what that means is that if an employer that owns a business employs 3 or more people, then you're considered as employer under this Pension Reform Act. And as a result of that, there is a need for you to set up retirement benefit for your employees. Now I'm going to jump into National Health Insurance Authority Act. And what that act does, what it provides for is that it requires every employee with 5 or more employees to make contributions to and also participate in health insurance scheme. And I do not know how many people have that in this room, and I don't know how much insurance employers provide for, but this particular act provides for that if you are an employer of labor in Nigeria, you are required, and you have about 5 or more employees, you are required to make contributions to health insurance scheme, which is regulated by the government. And what this does is that contributions made by the employers and employees are deducted from their income tax. So it's worthy of note to also define what employee means under this law. So they start to define employee as a person who is ordinarily a resident in Nigeria and is employed in the public service or private sector, or even as an apprentice with an employer. And to take it up to notch a little bit, whether your contract expresses it or not, you are covered under this. And also the statute also defines employer to mean an employer with 5 or more employees, with whom an employee has entered into a contract with, whether that is oral contract or any other one, it does not matter. So, but one thing worthy of note about this particular act is that the act neither expressly includes nor exclude temporary and casual workers. So I just wanted to put that out there. Then we'll talk about the National Industrial Code Act. So this is more of enforcement mechanism for the most part. This particular code establishes this particular act establishes the National Industrial Code Act, which has exclusive jurisdiction in civil cases in relation to labor matters in Nigeria. Next, we'll talk about Anti-Discrimination Act. And that law is referenced as the HIV and AIDS Anti-Administration Act of 2014. What this law provides for is a prohibition of employers of labor in Nigeria from discriminating directly or indirectly against workers based on their HIV status or any HIV-related illness. So what that means is that if you're an employer of labor in Nigeria, you cannot discriminate anyone based off their HIV-related illness or whether someone tested positive for HIV. And it's also worthy of note that the statute defines employee as any person other than independent contractor who works for another person and also receives or is entitled to receive any remuneration. So the statute appears to be very broad enough to cover casual workers However, exclude independent contractors. So that's something that we wanted to make sure that we highlight in this our report. There are also other industry-specific regulations, but one thing that is worthy of note is to talk about discrimination against persons with disability. So there's actually a law which was enacted in 2018 in Nigeria, which is called the Discrimination Against Persons with Disability Prohibition Act of 2018. And what the law provides for is that any person with disabilities do have the right to work on equal basis with other people, and also prohibit employers from discriminating against workers on the basis of their disability. So what that means is that if you're disabled in Nigeria, you also have the right to work, and there should not be any discrimination because the law expressly provides for prohibition against such. Specifically, Section 28 of that law imposes monetary penalties on employers who engage in such discrimination. So to the extent that, there's any employer that have done that in the past, I mean, to anyone that knows anyone, just let them understand that Section 28 covers you, even though you are disabled. So we just wanted to point that out there. Another one, before I wrap up, is another act that also governs workers' rights in Nigeria, is Industrial Training Fund Act. And I remember, I don't know whether Gani or Dennis mentioned this earlier about training your workers and all that. So this particular law actually requires employers to provide training for Nigerian staff to improve their job-related skills. So what this law does pretty much is it emphasizes, because as you all know, if you're a worker and you've not gone back to school or anything, or you just stop schooling because you're done. So this law, but you also need consistent training over time. So what this law does is that it provides for employers to provide that training to all their workers, pretty much. The law also requires employees having 5 or more employees, or if it generates a revenue exceeding 50 million naira each year, to contribute 1% of your, and I'm talking about employer right now, to contribute 1% of your total payroll to the fund. So there is actually a fund which is set up, and that fund is called Industrial Training Fund. So if you work with an employer and such employer has 5 or more employees, or they have revenue generating or exceeding 50 million naira a year, they are required to contribute at least 1% of their total employer's total annual payroll to the fund. And also, it's worthy of note to also talk about, in this particular act, what is the meaning of employee? So the law defines employee as any person, whether or not they're Nigerian, emphasis on that, employed in any establishment in return for a salary, wages, or other consideration, and whether such employment is full or part-time. What that means is that it also includes temporary employees who work for a period less than 3 months in a year. So the law therefore covers casual worker, as well as other workers as well. So on that note, I'm going to wrap up my presentation. Happy to answer any question later, and I'll pass the baton to Christina.
Great, thank you, Tolu, for that wonderful overview. And again, for everyone, there is a lot more description of each of these laws, as well as the few that were omitted from the slide, because we were just highlighting some of them on the slide in your guidebook. Okay, so now we're going to move on to international human rights laws and how they can help us advocate for workers' rights in Nigeria. So just by way of background, international laws that are operative in Nigeria can be broadly conceptualized as hard law. So these are the treaties that Nigeria has ratified or acceded to, or soft law, which is more the jurisprudence that comes out of the treaty committees, the recommendations that those committees make to the state of Nigeria after reviewing the annual reports that Nigeria must submit as part of its treaty obligations. and things like declarations of the United Nations General Assembly. The government of Nigeria has ratified all of the major international human rights treaties, and coming from the United States, to me, that is remarkable. The United States certainly has not done that. And so I just want to pause on that for a second, because this is one of the reasons that I think human rights can be super effective. Many African countries, including Nigeria, have really adopted a robust human rights framework by virtue of ratifying all of the major human rights treaties. And that's something to celebrate. But the idea is that if you don't use it, you lose it. So by using the treaties, and I don't necessarily mean by submitting complaints to the treaty bodies, which we'll talk about later, but by knowing about the treaties, by invoking the treaties, the language of the treaties, the rights of the treaties, we strengthen the treaties. We help people know that these rights exist and that the government has to make good on the promise it made by ratifying it. So I'm very encouraged by the broad ratification of all of the major human rights treaties by the state. I'll go through them very quickly at a high level, and there's more discussion in each or in the guidebook. So the ICCPR, that's the International Covenant for Civil and Political Rights. That is the treaty that it covers things like physical integrity, procedural fairness, equal protection, freedom of assembly, freedom of information, political participation, those kind of civil and political rights that we all think of. That was ratified by Nigeria in 1991. The ICSCR is the International Covenant for Economic, Social, and Cultural Rights, ratified by the country in 1993. These are the rights that relate to the protection of the things that are necessary to live in dignity, freedom from want, the ability to have an adequate standard of living, including things like adequate food, clothing, housing, and the right to work and just conditions of work. So, these rights are subject to progressive realization, which we'll talk about a little bit more in the next slide, but they're equally important as civil rights. They're interrelated to civil rights, and that can be demonstrated by the idea that the ability to form a trade union, well, that's a civil right under the ICCPR, but trade unions and their advocacy might be necessary to ensure that the workers covered by that trade union are getting fair pay so that they can realize an adequate standard of living and the ability to provide for their families. So it's important that the government respect the ability of unions to form and to be active so that the right to an adequate standard of living can be realized. And that is just demonstrating the interconnected nature of rights. Quickly going through the others, we have CERD, which is the Convention on the Elimination of Racial Discrimination, ratified by the state in 1967. CAT, the Convention Against Torture, ratified in 2009. CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, which was ratified in 1985. CRC, which is the Convention on the Rights of the Child, ratified in 1995. The Migrant Workers Convention, that was ratified in 2009. The Convention on People with Disabilities, CRPD, ratified in 2010. And then I accidentally left one off of this slide. Apologies, I was putting it together quickly. There's the Protection of All Persons from Forced Disappearance, which was ratified in 2009. Now, it's important to note that just by virtue of ratifying the treaty, the government is automatically duty-bound to implement it. That concept is part of the Vienna Convention on the Law of Treaties. That said, treaties in Nigeria, much like treaties in the United States, they're non-self-executing, which means that a legislative act must be taken to give the law its full effect. And so that's another thing that we can think about when we're wanting to give more teeth to human rights laws, especially as they relate to workers' rights, is how can we encourage the government to implement these laws through national statutes. And we have a model of that when in a moment we'll talk about the African Charter for Human and People's Rights. Okay, there has slide. So this slide just pulls together concepts from all of those different treaties that relate to the right to work and labor-related rights. So from those, the abolition of child labor and child exploitation, and the right to a safe workplace. So these all live in national human rights laws. Some of the treaties speak more to workers' rights than others. I think that, two I'd like to point out, two treaties that we can really lift up when we're advocating for workers' rights is the International Covenant for Economic and Social Rights. Article 7 of that treaty talks about fair wages and equal pay for equal work. And I learned from Dennis and Abdul in preparing, this research that people aren't necessarily treated equally and paid equally. There can be de facto policies such as get pregnant, get fired. So that would be discrimination on the basis of sex or pregnancy status. That is prohibited in international human rights law, as well as the Constitution. The Economic and Social Rights Treaty also talks about the right for women to maternity leave and paid leave. So those are some things that I think are important to think about when we're, with regard to women in the workplace in Nigeria. CEDAW, which is the Convention on the Elimination of Discrimination Against Women, also includes these concepts. The right of women to the same employment opportunities as men. So this would really call into question any laws that make it illegal for women to work in certain sectors, such as mining or others. That contravenes the country's obligations under CEDAW. Okay, I'm going to move on to the next slide. I briefly want to talk about the nature of states' obligations under human rights law. So when we think about the duty to respect, this means that the government may not interfere directly or indirectly with the exercise of a right. For example, with regard to the right to freedom of information and expression, the government shouldn't interfere with the ability of the media to operate. That is ICCPR Article 25. If we turn it to thinking about labor rights, the government shouldn't set a minimum wage that's lower than what a person and their family needs to meet their basic needs. And also the government needs to set a minimum wage law. These are just fundamental things that the government must do to respect a right. The concept of protection, the duty to protect, means that the government has to prevent third parties, such as businesses, from violating human rights. And the government fulfills this duty by effectively regulating third parties, so the business and industrial sector, and also offering effective remedies for violations. And this concept is often summarized in the jurisprudence as the duty to prevent violations, investigate, punish, and redress violations by third parties. Okay, and an example of this would be ensuring that employers actually pay into the tax systems that they're supposed to, that they actually pay minimum wage if they're covered by the minimum wage laws, and ensuring that the agencies that oversee these laws have adequate funding to actually implement the laws and make sure that they're respected. The duty to fulfill relates to taking progressive steps necessary for the enjoyment of a particular right. This could involve, this kind of goes along with the duty to maximize available resources, which is later in the slide, but this is things like raising taxes and spending money on programs that help people realize their rights. We've talked about the duty not to discriminate. The government cannot discriminate in its own programs, and it needs to prevent third parties from discriminating. The duty to prioritize the most vulnerable really goes to the idea that the government should be taking actions to reach the most marginalized groups who face the greatest barriers in realizing their rights. And I know that there's the Human Rights Commission, and it has offices throughout the country. That's a great example of the government, an agency of the government, really getting out there and interacting with local people and making sure that they are spreading information about rights and creating a space for people to talk about rights violations and seek redress for them. And lastly, there's the duty to monitor the realization of human rights that falls on the government. And this means that the government must design and implement methodologically sound tools to actually measure whether they're taking forward steps or backward steps. How many people are in the informal sector? We should know that. Is it growing? Is it decreasing? How many people have contract work? How many people are deemed employers? What percentage of the employers are paying into the pension scheme, the healthcare scheme, etc.? That should be regularly and completely monitored so that we have a good sense over time of how the government is doing as far as realizing rights. Okay, so now we'll turn to the regional human rights laws. The main one is the African Charter on Human and People's Rights, which was ratified in 1991. As mentioned before, this treaty has been fully domesticated into Nigerian law through the African Charter on Human and People's Rights Ratification and Enforcement Act. And, it mirrors in many ways the fundamental rights that are encapsulated in the international human rights treaties, and then it puts a kind of an African stamp on many of those, and that's where we get the concept of people's rights and collective rights. Notably, Article 10 protects the freedom of association, which relates to the right to form trade unions. Article 15 discusses the right to work, and again, that concept of equal pay for equal work. And, I think that we could, at a later time, or maybe the legal minds and creative people can think about whether that could be, that concept could be used to challenge arbitrary distinctions in pay between workers doing the same thing, but some of them are designated casual and some of them are employees. That's an artificial distinction. I don't know if that would fly under Article 15, but if, at the very least, Article 15 could be lifted up to challenge any laws or practices or the government failing to enforce its laws that require women to be paid the same as men for their work, women to be given maternity leave, and things of that nature. We also have the Maputo Protocol, which is the Protocol on Human and People's Rights on the Rights of Women in Africa. This treaty includes a very, very long list, very detailed and specific, of the rights of women workers in Africa. Oh, I'm sorry. Okay, thank you. Thank you, Abdul. And then the ECOWAS Treaty, which incorporates the African Charter for Human and People's Rights. And it's just, these are, other avenues that could be considered for rights redress. So I think we're trying to wrap up by 7 a.m., I think. So I'm going to just speed up a bit. We might skip some things because everything, again, is in the guidebook. International labor laws. Suffice it to say that Nigeria, again, has adopted most of the laws, most of the ILO conventions. And these go into greater detail on protections for workers. And to the extent that any of the lawyers are working on particular rights violations, I would encourage you to look at the corresponding ILO convention to see how it can help you kind of beef up and build out a legal argument and understanding of a violation. And with that, I am going to turn it over to Tolu again to discuss specific rights applicable to different categories of workers.
Thank you so much, Christina, for that. So right now we're going to be talking about specific right, and like Christina rightly said, we tried as much as possible to speed up a little bit. Most of all these things are already in the guide, so feel free to read that at your convenience, but I'll just go straight to most of all the right that we have. So the first right, this section pretty much, it's a statutory right under Nigerian law that apply to different categories of workers, whether you're a casual worker or you're a permanent worker or employees of small employers versus larger employees. So the first right is you have the right to written contract for workers. So what that means is that your employer has the right to give you a written contract, because this is actually is in respect to the Labor Act, which defines, as we stated earlier, the Labor Act defines what an employee is. So the Section 7 of the Labor Act requires that every employer needs to issue a written contract to the employee within 3 months of the commencement of the employment relationship. And what that must include, as you may see here, is it must include the nature of your employment, the rate and method of calculating your wages, the manner and period of such payment, the hours of work, whether you're entitled to holidays, and the notice period for termination. Also, it's also worthy of note that some of the implied terms in those contracts include your employer's duty to pay you wages, as well as provide a safe place of work for you. And you should also note that when an employer is terminating a contract, employer must ensure that you give employees appropriate notice of termination, or also you pay salary in lieu of such notice. As a matter of fact, there is a case law by the National Industrial Court, which indicated that the best practices in accordance with international standard is for employer to inform the employee of any reason before you terminate their contract. So the second right under the law is the right to your wages and also hours. As I said earlier in my last presentation, I talked about the fact that there is also no statutory limit on the numbers of hours an employee in a day, because the Labor Act provides that normal work hours are to be fixed by mutual agreement between the employer and employee. So that's something that is worthy of note. Christina, can you move to unionization? Thank you. So under the Trade Union Act, it defines trade union to mean any combination of workers or employers, whether temporary or permanent, and the purpose of which is to regulate the times and conditions of their employment. So that's one of the definitions under the Trade Union Act. Also, Section 40 of the Nigeria Constitution provides for the freedom of association for all citizens in Nigeria. So what that means, the combination, if you read that together, it means that as an employee, you have the right under the law to come together for collective purposes in order to advance your purpose with the organization or within your employment. It's also worthy of note to talk about a little bit touch base on the 2021 Human Rights Report for Nigeria, where the US Department of State noted that while the law in Nigeria prohibits anti-union discrimination, the law actually lacks adequate enforcement mechanism to protect the freedom of association and collective bargaining. So for example, the union require prioritization or approval by the government to form such trade union. So the process for this is very lengthy. You need a lengthy notice period. And it's also reported that the government often delays the deliberation and approval of such process. So which sort of like dissuade workers from exercising such rights. So just what you have not to know that even though we have this law here, the major issue, one of the backstop of the law is the fact that it's there's no adequacy of enforcement mechanism to protect that. Can you go to the next slide, please? Thank you. So we talk about the non-discrimination. So as I said earlier, Article 17 of the Nigeria Constitution provides for equal pay for equal work without discrimination, regardless of your basis of your sex or any background. But it should be worthy of note that this is not a fundamental right. It's not justiciable, meaning that it's not a right that's guaranteed under the law, but regardless, we have it under the Nigerian Constitution. But however, as I said, it's also worthy of note that, it's also worthy of, I just want to touch base a little bit, that the 2021 Human Rights Report for Nigeria, the US Department of State reported that women are overrepresented in the informal sector. And so women reported that a de facto, like when they get pregnant, get fired in the workplace. And these are legally barred. So no one should be discriminated based on whether they are pregnant at any point in time or anything like that. So yeah, let's go to sexual harassment, please. Yes. So I did touch a little bit about this earlier about sexual harassment. The law also protects Nigerian workers against sexual harassment. One thing that our research reveals, and as you may see in the guide, is that there's really no Nigerian civil law that specifically addresses sexual harassment in the workplace. However, we believe that there's some employers of labor, based on the standard and the sophistication of the employer, they have some guideline in place that actually prohibit workplace harassment and imposes penalty for the breach of such. But one thing that we should also note that there's some provisions under the Nigerian criminal law that addresses sexual harassment. But however, if it gets to the point of assault, and that involves like unwanted touching, physical intimidation, or other forms of extreme coercion. And that's about that. Christina, can you go to, yes. So there are also different rights applicable to Nigerian workers under the law. Basically, for retirement, the Pension Reform Act, like I said earlier, requires that employees of 15 or more people to contribute to a pension scheme. There's also life insurance available as well that requires the employer to obtain life insurance for you and to contribute a certain percentage into that. Also, like I said earlier, the National Health Insurance Scheme requires larger employers, if you have 10 or more employees, to participate in National Health Insurance Scheme and also to contribute a certain percentage of that to that. And there are other ones as well too. There's a maternity leave, which is pursuant to Section 54 of the Labor Act, that women are entitled to at least 12 weeks of maternity leave, and they're also protected from dismissal on account of their pregnancy. Can we go to worker safety? I'm going to try to wrap everything up pretty fast. So worker safety, we talked about that earlier. They're very, very specific in terms of, there's a Factory Act that provides that for wider spectrum of workers, that if you're exposed to occupational hazard, then you're protected under that law. And on that note, I will just wrap it up because in this trend until the next one. I think this is you, right?
Yes. Our act can carry civil and criminal penalty. We'll talk briefly about mechanisms for enforcing rights. There's, of course, the National Industrial Court, which has exclusive jurisdiction over for labor and employment claims in Nigeria. We understand it's typically used only by highly paid workers in the formal sector and very rarely by lower paid workers, but who are casually employed because of the expense of obtaining legal counsel, which is an area where we can help kind of bridge the gap as pro bonos. Mediation in ADR is a tool for the resolution of conflict between employers and employees. I would suggest this is a very ripe area for pro bono intervention. Parties don't necessarily need to go to court to resolve issues that involve discrimination, workers' comp claims, and wages. Mediation can be used to resolve disputes instead. Then we have the Public Complaints Commission, and I hope that we have a representative here today who might shed more light, but we understand that there's an enforcement unit within that designed to address employment complaints. Similarly, there's an online complaint form that is very user-friendly. And although the Public Complaints Commission, we understand can't really issue judgments per se, the outcomes of its investigation could later be used if the issue is litigated in court. The National Human Rights Commission also takes complaints relating to labor and workers' rights. We understand that in 2021, the Commission reported receiving over 1 million complaints, and a great number of those, and while their determinations also are non-binding, a favorable determination in a resolution with their employer. So we should definitely think about using all of these tools in our toolbox. Regional mechanisms, we have the African Commission on Human and People's Rights. Individuals who have experienced rights violations can submit a concern to the commission. The state of Nigeria, we understand, hasn't accepted the jurisdiction of the African Court on Human and People's Rights and the ability for complainants to lodge complaints directly with the African Court. So the commission is really the avenue that you would use. However, the commission can refer cases that it receives to the court. Then there's the ECOWAS Court of Community Justice. And interestingly, it's charged with resolving disputes related to the ECOWAS Treaty, which we know incorporates the African Charter on Human and People's Rights. So it does involve human rights complaints potentially. And it has competence to hear individual complaints of alleged human rights violations. Litigants are not required to exhaust domestic avenues of relief before bringing a complaint before that court. So I think we should really, consider using that for serious violations as well. I'll speak only for a moment on international mechanisms. Suffice it to say that there's that Nigeria has accepted the competence of the CEDAW committee and the committee that oversees the Convention on the Rights of People with Disabilities to hear individual complaints, but to use those complaint mechanisms, individuals do need to exhaust domestic remedies first. So it might not be, as easily accessible for folks. Remedies for violations, we understand typically involve compensatory damages for things like wages that were not paid. They might involve reinstatement of employment. We understand punitive damages are rare in employment cases in Nigeria. And as noted before, casual workers rarely access the national courts that could render these remedies because of the expense of accessing the legal system. We've touched on this before, just a summary of employers' duties. These could be used as talking points when lawyers are engaging with employers to educate them about their duties. And lastly, we have recommendations. I'm not going to go over these because time is now up, but we have, as part of our guide, made recommendations to the government as well as to employees and employers and civil society of how we can advance the cause of workers' rights. And we can think about these when we're counseling employees, simple things like asking your employer for a written contract if you don't have one, asking your employer to clarify what type of worker you are, and then enlisting an attorney to help with those discussions if you need to claim your rights. I would like to spend just maybe 1 minute on pro bono resources. As we said at the beginning, pro bono lawyers can really fill a gap in helping employees, workers who are less powerful in the power dynamic with employers and realizing the rights that they have under the laws of Nigeria. We hope that pro bono attorneys will use the information that we've shared through this resource to counsel workers. So to share information and, in certain cases, maybe to represent them before quasi-judicial mechanisms and courts. There are clearinghouses in Nigeria that can help screen potential clients so that when the lawyer gets the client, the case has already been worked up and you know what you have to counsel them on. Public Interest Law Partnership is one such resource. We already heard from Adobe from New York City Bar Association Vance Center, and she'll speak with us again later about how she can help in kind of developing the pro bono clearinghouse model in the country. And then Nigerian law firms are already doing this. For example, Fred Young and Evans, that might be able to support other law firms as they're kind of getting their programs up and running so that they can help counsel some workers who need advice and support. So thank you again for your time and attention, and we'll be very happy to answer questions.
They are talking whether.
Okay, I said it's time for questions. So we'll take questions from the participants with us here, and then we take 2 online participants questions. So if you're online, you will need to unmute so that you will be able to ask us the questions you have. And if you're unable to unmute, you can just type into the chat your question.
the public sector is. What is left for us in the private sector? Government has a lot to do. We are really handicapped in the private sector. And unfortunately, they are non-justiciable. You cannot go to court and claim. Take, for example, the Pension Reform Act. 15 employees of that. If your office are barely 5-7, what can you do? Pension contribution, that's the best you can get. So in Nigeria, the majority of the workforce in the private sector, we are really handicapped. There's nothing we can do. Believe me, that's the word. Minimum, the rest of this act, the Employee Compensation Act, National Health Insurance Authority Act, and all of that, they have limited application to the private sector. The Employee Compensation Act applies only to injury and death. Any other wrong, you cannot go under that act. It applies only to injury and death. Government has a lot to do to protect the private sector. Thank you so much.
Thank you. Maybe I just don't know who among the two you directed to any of them.
General, yes.
Okay.
It's once
Okay. So Lou is up to you, or Christina is up to any of you to answer. And I hope you got the question right.
I didn't hear the question. Christina.
Yes. Hi.
I didn't get most of the question.
I did not hear the question either. I'm so sorry. I'm not sure if it could be typed into the chat.
I think yes. All right. So we will just take the questions and then come back for answers from you. I think it will be better that way. Okay.
Hello, everyone. Listen to your attention. My name is Edith, and I'm from NBA. You listen with rapt attention to and I got the words as I'm not very lovely. These laws as they proceeded and as so explicitly delivered on you are to a very great extent non-applicable in Nigeria. Mr. Tobu Adetayo, I've directed this specifically to you. And the reason why I am putting it this way is because the economic situation, the economic status of Nigeria as a country today has made the employer a demigod, such that whatever the employer dishes out of the employee, the employee is forced to take it without any of these laws being applied to civil revenue. Case in point is the issue of very poor wages or salaries, as you put it, poor infrastructures for disabled persons in public organizations, and long work hours, benefits, allowances, and much more like that. So what you have so beautifully delivered this morning. How does the Nigerian worker within the public or even the private sector apply these in seeking better working conditions considering the fact that the economic downturn in the country has made it so very difficult, difficult and exercise working conditions.
This last question is directed to
this issue what do you think? What do you think of this anti-discrimination act itself is discrimination in the sense that it focuses more on persons who are living with HIV/AIDS. And then disability. But this is a country where when the child reaches primary school, except for privileged homes where you go straight to secondary school, in some families or majority, you have to walk around the community for many years before you end up going to secondary school. After secondary school, you have to do menial work or sell by the roadside and work to gather money to get to my institution. And then at graduation, you're not looking for employment. They say 5 years, no more than 27 years. That person is graduating at 27 or even 30 or even more. And you are saying that you must have 5 years experience and no more than 27 years. And this happens everywhere. In all sectors, both private and public. Even in the military. The military is worse. They are reduced to you don't apply for more than 22 years. So, anti-discrimination act itself is in terms of age of persons seeking employment. The issue of age not be properly when you have a don't you think that the issue of age not being addressed in our in that law also is discriminatory on employer capacity and
okay, next question, please.
Let's evaluate that all are like the rights of Nigerian workers in the land. But we have not customized these rights into the local environment. So a challenge all those rights. The challenge is localizing these rights.
Not using my
because area where the challenge, especially in private sectors, is number one, you need to sharpen the negotiation skill of workers.
negotiation, what type of progress? In the context of the rights in the various laws, I think that's the challenge that we have in the CYPLP. Because just like right now, if you want to make a contract, it's what agree with the employer that becomes enforceable. So if you don't have the ability to negotiate some with what time to do, within the rights and freedoms, then of course we just be there. So I think the challenge that we have in Nigeria today, considering our poor academic and economic status of most is to be able to share energy and contextualize the local environment.
One more.
My name is Peter. Thank you. Actually, all massive, but it's more or less more for people. My question goes to the nature of state obligation to workers. As we all know, that Section 2 of the 1999 Constitution, those rights are more or less non-constitutional rights. Most of these obligations are not enforceable. So why do we enforce the state to carry out its obligation when the law itself makes those obligations not? How do we enforce the obligation of the state when those rights are not justiciable? They are not justiciable at all. So how do we enforce it? Because at the beginning of the of the 1999 Constitution, and the rights those speak out, they are not enforceable. So how do we enforce the state to carry out this obligation when those obligations themselves are not enforceable constitutionally?
Ministry of Justice. Sajana Sir from the Ministry of Justice Sector State. My question is also on how to enforce these laws. We have very beautiful laws in Nigeria, and it will even surprise you that such laws have been participated. For example, disability law, we have it in Katsina, discrimination against persons living with HIV is also in Katsina. But anytime I appear in gathering, always want to meet. The laws are just there. How do we implement it? I feel the discussion should start towards, I don't know, those CBOs, we're all here, all of us are stakeholders. I think the discussion should now start tilting towards the implementation of these laws. So this is my question, and I think the solution to answer how do we go about it.
Okay, as I think we check the stories and we check so many on what have been said or been presented. About all talked on is that laws are there. We must say, you know, in CSOs, we call the accountability. I have handled so many issues that people usually pass on and handle. But I worked in Abuja. Worked in Abuja. It's an oil company. I don't know what it had with the boss. So the job was somehow terminated without any termination. So 2 years after the termination, he was not going to work. And he was enrolled in this pension scheme stuff. So he was not paid salary. But 3 months, he's getting alert of payment of the pension. So he's simply getting the salary here. That's what simply. So he has lived like that. And so he was for money. The purpose relationship with them. So along the line, was across someone who's very good. And we got something. I said, okay, I want to see your document. So I look at it, I said, okay, letter of appointment, fine. Letter of termination, that's no way. Okay, I know what you are, just be behind the scene with you. I'll guide you on what to do. The other company, you know, they are good words. You have all the legal balance. So I said, the first thing you need to do is to complain to them. What is going on? If you don't complain to them, the right information. So we'll send them to realize so that they will receive and acknowledge. So we have established that we forwarded the email. So we need that they receive. When they receive, their legal team, started writing us in English. Now, threatening to even arrest you and all that. Interesting. There's limits to what they can do. In as much as we can investigate, so just people have. What were not solutions? We asked them, we demanded for termination of appointment and then asked for the 2 years salary. Okay. So we started from that point. Then later on, I said, no, we have to engage public complaints commission. So I engaged public complaints commission. Because we might say, you are to ask complainant, I will be behind you. So the process started and all that. What the long story short, at the end of the day, that man was good. He was so shocked. So he got the money. When he got the money, he said, that's not right then. Now you terminate that your person. You also have right to terminate yourself. It is not only the employer that terminates. You also have right to terminate. I said terminate that body. So that you close to the collected money. Let's close that. Why not? So he wrote them and terminated the appointment. I said, okay, now you've terminated the appointment. We are now going to ask for that pension. Because if you don't terminate the appointment, you cannot ask for it. I said, you still have another money that you use for it. So terminate yourself. Because they don't want to terminate you so that you won't go for this. Because that one is, by the act, it simply means that until you are terminated, you cannot access it. So I said, terminate yourself. So we terminated the appointment and then go for the pension fund. And after you go with the slicing and material, how very is better than. So that's just the thing. employers. It's just that even if you're in the courts and you have the right to speak on the issue, if you don't speak it yourself, you don't speak it. No matter how good that your matter is, he expecting you to say it. And you're not going to come and say it for you. If you the only way to say it is sit and say this. Okay. All right, so we hand it over to if you can answer the questions, please. Up to you now.
Can you guys hear me?
Yes, you can.
Oh, okay. I think the question. I'm going to address. There's the background noise. I'm going to address the issue of non-deductibility of the Nigerian law. Oh, sorry, there's a noise going on here. It's very distracting. Anyway, let me just jump into it. I think there were two questions on non-justiciability. And totally agree with you guys on why that is an issue, especially when it comes to Section 2, and I also refer to Section 17 of the Nigerian Constitution, which basically talks about the fact that these are rights on paper, but they are not enforceable. So for me, I think addressing the non-justiciability under the Nigerian law, especially in relation to labor law, is a very complex issue. You know, the Constitution includes in Chapter 2 covers objectives and directive policy. But those principles are basically intended to guide the government in promoting justice, as you all know. So I think in terms of practical steps to do that, I think about it in 4 ways. The first step is to enact specific laws, right? As we already have laws against discrimination for people with HIV/AIDS and disability, that's one of the ways to do that. So if the legislature can actually have, can enact specific law. Did we lose them? Oh, we're good. Okay, sorry. So pass specific legislation that makes those principles enforceable. I think that will be the first thing that we should be thinking about. Another thing which I believe is a very tall order is to amend the Constitution itself. If the Constitution can be amended, definitely we can make those directives and principles justiciable. And it's to allow individuals basically to seek redress in court and enforce their right. Another way to do that pretty much would be judicial interpretation. And as we may know, with most of the laws in Nigeria, I think if we can have the court interpret existing justiciable rights broadly so that they can include socioeconomic element from the directive principles, then that would also make sense. For example, if the right to life could also be interpreted to include the right to work in a safe environment, then that makes sense. But that might be a very tall order to ask, but judicial activism in terms of interpreting those laws in a very broader perspective would actually make sense. And I think another thing from the judicial interpretation could also come from the point of judicial activism. Judiciary can adopt activist stance and find ways within that framework to sort of enforce the spirit of the law itself. I'm trying to remember, there's a particular way saying in Nigeria that, I can't remember, that the law is, anyway, I'll just skip that for now. I'll just focus on other things. But what I just wanted to mention is the fact that the law itself can just be a paper, right? But the justices of the court, as officers of the court, can bring life and spirit to the words and letters of the law itself. So I think that's something that is very important. Another thing that is also important is what we're doing here today, advocacy and civil society action. I think there's a need for NGOs and labor unions to increase awareness about workers' rights under those directives, as we have done today. I don't know how much of lobbying we can do in Nigeria or we have in Nigeria, but that will also be a good way as well, where if we have like labor unions, lobbying politicians and lawmakers to enact the specific laws that I mentioned earlier. And another thing we can also think about is international pressure, like the human rights report that we mentioned earlier about what the United States Department of Policy thinks about most of our laws, those things can also put some pressure on the government and all the lawmakers to enact new laws. I think the last thing is from the perspective of administrative measures. So since we know that those directives are not enforceable, I believe that government agencies can implement policies that reflect those directive principles, even though they're not enforceable in court. So for example, by including labor standard enforcement through the administrative bodies, that's also one of the ways to do that. And another way in terms of administrative measure could be using existing laws. So we can also like use existing law, like the labor laws that we have, to also see how we can incorporate most of all this directives and policy into what we already have. And as I said earlier, it's the issue about the chapter 2 of the Constitution. It's something that remains very complex. But if we can go through those things that I said, regarding I think age discrimination. Am I right? Christina? Okay.
I couldn't hear the questions, but yes, in the chat, there was a question on age discrimination.
I think when it comes to age discrimination, and I think from the chat, I also saw that it talked about the fact that there are specific laws available, but those laws actually only protect people with HIV status. And I might be wrong. What the law provides for that, I think once you are 65 years of age, you're no longer allowed to work in Nigeria. That's retirement age. And I also think, I think it's 60 years or after 35 years of service, whichever comes first, which is a standard for civil servants. But for private organizations, I think that mostly just depends on the ability for you to perform your job. That's what that basically depends on. So I think in terms of what the law requires, there's really no requirement for explicit age limit within the Nigerian law. But however, I think what determines whether someone is eligible based on age is dependent on the private relationship between the employees and employers. But however, for most public sectors, the retirement age, like I said, compulsory, that no one should be discriminated. So I think that's how I'm looking at the age discrimination part. And also there's also awareness part of what we're doing here today. There should be awareness to educate the public about the benefit of age and diverse workplace. For example, age comes with wisdom and experience. So we should also try to impact that as well. I also feel like the judiciary also have a role to play in case those issues get to court, in order to sort of like broaden the interpretation of, to the extent that I think I did address that question. I did address something about disability earlier, because we already have a law in Nigeria that provides for protection of any disabled in Nigeria. But I don't know, one of the greatest issues we have with Nigerian laws and even everywhere is enforcement. So perhaps more often than not, they do not have the economic resources to be able to litigate those issues in court. And to Christina's point, we need to incorporate the culture of pro bono in Nigeria as well. So in addressing those issues, because imagine when you're getting paid 30,000 naira, for you to even engage the services of a lawyer, it's going to be more than that. So, but however, if we have people that volunteer for pro bono services like we do here, we have some sort of like laws and policies that around that, the fact that you have to have a certain number of hours for pro bono basis on a yearly basis. And as a matter of fact, that's some states in the US where if you don't even do that in a year, they can assign a case to you. So I'm saying that to say that one of the ways we can actually address that issue potentially could be advocating for more pro bono lawyers and lawyers getting involved in pro bonos. So I don't know if I've addressed all the questions. Today, address anyone. Please ask this question, and I'll definitely touch base with them.
I think the training room might be on mute. I'm not sure if anyone else is asking questions in the training room.
The training room is on mute.
Yes, we can hear you.
We move to item number 6 now. So we're taking presentation from online embassies and our partners. So we'll give the floor to our people. Just 5 minutes, please. Thank you. And I'll be pleased to take the floor. Hello, Adaobi, are you there? Hello, Adaobi, are you there? Okay, we'll come back to you later. Okay, so we'll take from here. We'll take a message from NPO.
Yeah. Check. Gawa.
Okay.
Have you?
This is the one. If I'm not, where's the one?
I am the of the chairman and members of the Member Association. I've been obliged to be here and to bring a good message to you for this wonderful program. So much has been said. I want to add my voice. One on the issue of and I have to say that the so far, which is not even feasible, is not the living wage, considering the rate of inflation in this country. And what we enjoy to do more of advocacy to drive the various points made here home to relevant authorities. It has been said that the only way that the rights of the Nigerian workers can be made justiciable is by amendment of the Nigerian Constitution. And I totally agree with that. But that's going to be a peculiar tax because it has to go through the state bodies for it to come under the relevant provisions of Section 33 to 45 of the 1999 Constitution of the Federal Republic of Nigeria, which caps the fundamental rights. Otherwise, the laws, as beautiful as they are, will remain paper tiger laws. Thank you so much.
Thank you. So, forward on legal exams. Live business, please.
Good afternoon, everyone. I'm to stand on page 24. As I earlier mentioned, my name is Charles Basso. I just commend this program as further broadening my perspective of the workers' strike. So I stand here today to shed light on what most of us have ignored or shied away from, which is the workers' strike. The workers, as we know, have been most workers, many workers are marginalized. They are oppressed. Yet some of them do not even know where to go to for the rest. That's why we, talking on behalf of the Legal Aid Council, are mandated to assist these people by educating them on their rights, on such rights, to also seek legal representation, to represent them on such where they have been marginalized or oppressed. As a vital part of the society, working tirelessly day and night to provide for their families and also their community and the society. They are the backbone of the society. Yet, when an employer is terminating a worker, they do that without looking back. And this is not fair for the worker. So the legal aid, which we know is mandated, the Bono services, even though we also do contributory legal aid services for those of needs, those that can also contribute that.
We stand for these people because they have so many rights that they are unaware of. And these rights, as we have discussed today, are on paper because they are not obscure. So we are here to try our best to an extent for these workers to at least smile. And where they have been dismissed wrongly, we have many cases in our organization. By our intervention, these people were reinstated. So these are some of the things we have assisted in doing, and we keep doing it, and we'll do it tirelessly. So we all here today can, as advocates, to also help without holding our hand to ensure that justice is carried out on all such people. Thank you.
Thank you. Yes, please. I realize we have 2 days. So we have no, they have rights to talk. Yes, they will talk. And also to add to that, so that we will get motivated. I took that knowledge for me. Everybody says it's not on the work. Because everything is talking about the power, until you like it in action. You can move out. What did they do? They asked people to buy to that time. So if you don't buy, you cannot, then it's not from 1,000 and I went and saw the I have right to choose what I want to buy. You cannot force to buy a 1,000. It's not that simple. So it's there. Being there, it's there. I went and I looked at it. So the better one is that we just have to get how to translate things into concrete realities. So this is
I want to bring you meetings from the chairman and other members of the Umbrella Association. What we have experienced here today is something very good. It's commendable. Ask that more of this so that they are better and wider enlightened. I would want to say that it's only when someone knows that he has the rights that person will begin to explore the reasons. The person doesn't know that the right exists. The person will not use the experience the rights. A lot of Nigerian workers don't know anything about their rights. Because this issue of unionism, trade unionism, has been controlled, has been regulated. What to give an example? I do not think that many Nigerian workers are aware of that they are supposed to work a certain number of hours in a day and a week. And then eventually exactly and that person is exceeding that number of hours, the person is entitled to stay it's only there a thing that know about it, and it's only a that they reach for such and you also know that there are also workers There are also so many workers who are not aware that they are entitled to annual leave. A lot of them do not know that they walk around without taking even 1 week off. They won't do that. What I'm saying is, there should be more resilience. The stakeholders, the trade unions should be better. Yeah, so many trade unions. You have Nigerian unions. They should be better. So that by the time they are aware of this, they step back to the workers in the field. So that the workers in the field will be aware of that. So when they are aware of that, and they will begin to ask, what do we do when we cannot access some of the things that we are entitled to? And that is where they created that they can access the ATAs and the services, and that they can access the paid services. All those things on paper, just like my senior said, just as the ornaments for the conference.
Thank you very much. We are having a launch of this week on the 1st of May as workers day. And so we are involving all the layers. We are having a launch on the 1st of May. And so we've already thought about it. Then we call the National Human Rights Action. Anybody from National Human Rights? Human Rights, National Human Rights. Anybody? Okay. James Father. Okay. Public Complaints Commission.
Once again, my name is Minor. I was really commend the organizers of this forum. Last year I was here, I participated in one of the events, and it appears that they are increasing their effort. So this time around, I will find a more larger venue. However, what I tend to say is that from the perspective of the Public Complaints Commission, which is an organization that was established back in 1975, was to ensure that administrative injustice is being corrected in Nigeria. So basically, the Public Complaints Commission is an institution of government established as far back like I said in 1975 to ensure that those rights, citizens are being protected. Why was the Public Complaints Commission introduced? As a result of the increased activity of government, which now give me more activity than what has been present. And I'm busy to present us here. Some of them are talking about the rights of employers, particularly in terms of condition of service and how to lead. This forum is actually to present an opportunity for the Public Complaints Commission to seek further collaboration with other institutions, so that at least we will enlighten the public with the right of citizens and what the mandate of each institution is all about. So, like I was saying, there are landmark successes already by the Public Complaints Commission. The latest study is one Mississippi Chica, a nurse who was accused of stealing. A matter went to court. They just formed an administrative panel of inquiry. At the end of the day, she took up the matter with court. At the end of the day, the matter lasted for 16 years. And ECC made the legal documents ended. 10 days, because there was no legal issue. It was her right also. That was work for more than 15 years. By entitled to certain business. which the commission pursued. And at the end of the day, she was given termination letter, and she placed all her other career progression entitlement. So what I would always say is that we should increase the level of cooperation and enlightenment so that the citizens will understand the basic.
Thank you very much. Last year, I know it was one of our facilitators. I think it was on business and human rights that we engage companies, private companies, how to do business responsibly. So we call Minister of Justice, say something.
Good afternoon once again. I'm Diana, Senior State Counsel of the Ministry of Justice. I would like to start off by commending the organizers of this program. This is a very wonderful program, and I'm glad that I'm here, we're all here. And I would also like to extend more regards to the General Commissioner of Justice. And also, I would like to assure the organizers that we have listened carefully every conversation that was held here. And as stakeholders, as a ministry, which exists to improve effective response to justice systems in the community, in our report, we'll record everything that has been said here. I will come up with recommendations, and we shall also do our own bit, particularly on creating awareness on issues and on laws that we have on ground that a lot of the public are not even aware of. We'll play our own role, so particularly on this issue and so many other issues that we discuss after. So thank you very much, and I congratulate all of us that are here. I believe we are making history here, and one day we'll look back and say we are glad that we did this. So thank you very much.
Thank you. When we bring our advocacy in defense policies, please give us attention.
Oh,
okay, so we'll call on ADR. ADR is very important because it's not everything that we do to court. You know, I think it's one of the ways that conflicts, you know, can really get resolved before it becomes crisis. So, ADR. Thank you very much. Okay, we go back to Adaobi. Adaobi, are you ready? Yes. Adaobi, are you ready? The floor is yours now. Just give us 5 minutes. Talk.
Do you hear me?
Yes.
Okay. Okay, thank you.
Also, thank you. Thank you so much for inviting me. I'm sorry that it has been a mix-up throughout. My name is Ada Obi Ebuka. I direct the Africa programs of the Cyrus Arvan Center for International Justice, which is a nonprofit program of the New York City Bar Association. It's a pleasure to be here and to really see and hear the great work that has been put in this document and this particular issue about labor rights. My goal is really to just inform you about the Venn Center. What we do really is to promote and support pro bono across the globe. I have followed up, without boring you because I now have 5 minutes, I had followed that up in Africa by really looking at how countries in Africa can begin to support pro bono. We want to agree and believe that many of us already do pro bono. You will see that we say we're already taking on pro bono with our family members, church members, and different areas. But our goal has really been in two ways. One has been to really provide pro bono legal support to nonprofit organizations. And I know there are many of you in the room. The idea really is understanding that a lot of nonprofit has a lot to deal with, working with communities, trying to raise funds, trying to at the same time make carry on advocacy and at the same time pursue legal changes and issues in courts. What we are doing is really finding ways to support such NGOs. So I have worked in Nigeria for many years, and you can hear from my accent, fully Nigerian. I worked in a nonprofit for many years in Nigeria, pursued and supported pro bono in Nigeria before coming to work in the US. And I realized that a lot of times there are many issues that we want to pursue, we want to work on, but most times capacity, funding, lot of things to deal with, and we let them slide. So what organizations like the Venn Center, and I also see Trust Law here, do is really to find ways to support such NGOs. How do we ensure that when you want to file a case in court, you are able to get legal support with legal research that entails international legal mechanisms, regional legal mechanisms in case you want to use the ECOWAS or the Commission. And even when you want to file within Nigeria, there are also Nigerian law firms that we work with who are also willing and able to support such research. So we've had effective engagement with the likes of Olaniwo, Aluko, Templars, and the rest of them. And at the same time, so the goal is really to ensure that, like I heard Tolu talking about judicial activism and how that could change the bars, encouraging NGOs in the room to do that, bearing in mind that organizations like ours are available and willing to support you with providing you with comparative analysis in what's happening in other countries and providing you with materials for your research to take the actions to court, even advocacy. We've also had situations where we're able to support with legal information to guide you as you go to the parliament to talk about the justiciability of these issues or try to make advocacy changes in the in the National Assembly or House of Assembly. So that's for the NGOs, right? One of the things we have done or we do is to find ways to encourage lawyers. Many of us are lawyers. I'm a lawyer, I've practiced in Nigeria for many years too. We find that so many times we're struggling with trying to keep our client base and we're wondering, we're already doing this for our family members, why do we still want to do pro bono? What we have done in Africa is really trying to encourage African law firms to realize that apart from doing public good and taking the bosses, there are also business opportunities and business gains in taking on pro bono cases. One, they are supporting to see that the laws are expanded, people get help, and there are changes both in court and in the assemblies. But at the same time, as a law firm, we have created avenues to have interactions with other law firms like we have here today, where law firms are interchanging and learning from each other. How do you as a law firm grow and support and really document and show off the pro bono work you have done in your firm? So in that way, you are able to attract more clients to yourself in different areas you have developed. We've also found pro bono is also a very good way that law firms strengthen their skills, encourage their lawyers to learn new areas. We're talking about labor rights today. And if you're able to find ways to support nonprofits who are doing this work, that sharpens the skills of your lawyer, that exposes you to those kind of area of practice which you may be doing or may not have started doing. But so these are like different ways we have mapped out to, one, encourage law firms to take on pro bono, two, begin to build data. So in that, we are able to showcase the number of cases law firms are doing, in what way they are doing it, and really encouraging clients and businesses and supporting NGOs in the long run to drive pro bono. So these are some of the things that we have done. In Nigeria, I know that there is this clearinghouses too for lawyers in the room. There is the Public Interest Law Partnership in Lagos. There's also the Pro Bono Clearinghouse in Abuja, whose work has really been to connect issues on ground with NGOs and groups on ground with lawyers who are in need or who want to provide legal services. So at the Venn Center, what we have done is this and more, but I wouldn't bore you with all of them. But I just want to encourage all of you that we're beginning a movement in Africa, a movement where we're driving law firms to see the need to take on pro bono work, to see the need to develop a pro bono department in their firms, to see the need to, across the region, to discuss and share and cross-pollinate ideas on how to strengthen law firm, how to strengthen pro bono in their firms. For the NGOs in the room, you work so hard, you take on this lots of diverse cases. These are labor issues that we're talking about here, which is a novel area that many hasn't really been exploited or used or supported a lot in Nigeria, and encourage you to think about pushing the bars, think about giving life to laws that we've heard today. We heard about the Disability Act, which has been in place in Nigeria. Let's give life to it by finding individuals whose rights have been violated and taking up such cases and pushing the bars of the court to get judgments that will go a long way to not just affect one person, but more of the community. And we're here to support you if that's needed in terms of making sure you have the right research. You need an amicus to be filed. We're happy to do that. There are things that you want to do. We're happy to provide such services. So that's just my encouragement to NGOs in the room. I also know there are media in the room. I also want to tell you that we have seen the impact of the media in Nigeria. And that's why I really felt that this workshop today was very good in the sense that they have brought the key stakeholders, both from the government side and also from the other key stakeholders to the room. And so the media, this is a time for you to take what has been said here, support NGOs and law firms who are willing to support these issues. We know that sometimes we take on strategic litigation, not just to win, but to bring the issues to limelight. So this is a time for the media to partner with NGOs and law firms in the room to ensure that we identify pertinent issues that needs to be addressed, pertinent issues that we can get judgment in the court, and support them, make press releases, put it out there, and so people get to know what's happening. It's one thing. I heard somebody talking about the private sector and its dynamics and enforcement. So a lot has come out of this room, but we know that we've gotten a lot of things done through media advocacy. So we encourage those who are here